So now I'm going to get to the Montana cases, which are very interesting. The PPL case, the DNRC, just because the state agency tells you so doesn't mean it is. Keep that in mind. The DNRC, after many years, decided that, golly, we could make money if we made those guys who have those dams in the rivers, for making energy, if we decided that the stream beds of the rivers are school trust lands. And if they're school trust lands, then they have to pay, often in dollar, because that's what in the state constitution. And then that means PPL has to pay. And they said, we're not going to have them pay what the land is worth. We're going to have them pay shared net benefits. So PPL is supposed to pay a percentage of the profit that they've made out of Montana for their dams that have been in the streams for, decades, that now the DNRC has decided is state property. And the extension of this is like, oh, so sorry, PPL and those big companies, they have to do that. Don't you see what's coming next? If they win at this level, it will come down to the irrigators. Anybody who has a diversion dam in a navigable river, that will be found, if that's found to be school trust lands, all the school trust laws will then apply to your diversion. And you have to pay market value to the state for using that. Lastly, I'm going to talk about the Hohenlohe case. And this is the one that's most important and tells you how important it is that we figure out and we all understand what is the property interest in a Montana water right. Now in Chicago, they call this process extortion. Here, it's just going through the DNRC transfer process. And I have friends that work at the DNRC and I like them very much and I believe that they think they're doing their job. I just think it's the nature of government to grow beyond their limitations and try to do more. And in this case, I think they're taking water rights. So in the Hohenlohe case, it's about some ranchers who have a pretty large water right, and they wanted to do an in-stream flow lease. And so they went out and they measured it, and they said, well, here's our application. And the DNRC said, well, you can't do that. In the past, you used way more water than our little charts say you could put on that ground. And because of that, we can't grant your application. Now, Hohenlohe, it is a very large volume of water. I'm not going to talk much about that. However, in the Hohenlohe case, there are no senior water rights holders near that can be adversely affected. So it's like, where do you measure your water right? The issue is, do you measure your water right at your point of diversion? Is that where your acre feet or your CFS? Where do you measure that at? And the DNRC says, oh, you measure it consumptive use. And we usually use alfalfa because alfalfa uses more water than any other crop, so we're really doing you a favor because you probably didn't grow alfalfa. But alfalfa would have used this much, and based on how much alfalfa would use, that will be the measure of your water right, or how much water the most consumptive crop could consume. That's the measure. That's not what state law holds. State law holds that if you have a pre-1973 irrigation right, that the volume is how much you historically used, which includes if you had a very leaky ditch. Now, when does a very leaky ditch convert to waste? We're going to have to figure that out over time. But the reality is it takes water to move water. Therefore, if your water right is trimmed down to consumptive use, basically your property right, which should be measured at the diversion point, not at the field, has been trimmed in the transfer process. And lo and behold, if your property right can't be transferred, let's say people will say, well, maybe it should just be consumptive use and it won't affect your property right. Your property right is what you can measure and what you can transfer to someone else. And if that water right is trimmed because of these different definitions, then it has been trimmed. The other issues that come into play in the Hohenlohe case is what is waste and what is salvage. And the most important thing is that the DNRC, we did an amicus brief for Farm Bureau on this, and they're very good at allowing me to hit on some of these important issues. Normally, if you do an amicus brief, the reply brief of the government or whoever's on the other side, they just kind of ignore you. They mentioned us like 10 times. I think I got under their skin. Maybe it was the word extortion. And this case could have been just about the narrow interpretation of the trust water of the in-stream flow statute and what you can transfer. But oh no, DNRC decided that they were going to try to get the Supreme Court to define what is historical use, and they're trying to get that into not beneficial use and have it limited to consumptive use. And the DNRC got a little bit of salvage language in there. And of course, salvage is, and the legislature passed a law, I don't know how long ago, about salvage, and they said, look, if you're going to convert to get more efficient and convert from flood irrigation to sprinklers, you can have that salvage water. The DNRC was in another case recently. They said, well, you can't do that unless you come to us. But Judge Swandell said the legislature probably meant something when they wrote the law, and you don't have to go to the DNRC to do salvage, as long as you're putting that water on lands associated with the original waters. So again, to kind of end, you have, for water rights, you have a right to use water, and it's very important to know where you measure, where you start from. Do you measure at your diversion point, or do you measure in the field like the DNRC wants to do? And it's very important that you have a right to use a certain amount of water for a certain use at a certain place for a certain amount of time. And if in the process of transferring that or leasing it for in-stream flows, the DNRC can trim it. You know, it's like, what do you do at that time? You either say, well, I'm going to pay, you know, thousands of dollars to an attorney and fight this, or you say, I'm just going to go along with it because at least I've got it done. And I say that's where the extortion is.